Today on Legalese, we are talking about the bump stock ban case of Garland v. Cargill. Hey, greetings everybody, and welcome back once again to Legalese. As always, I'm your host, Bob, and want to thank you all so much for joining me here today. Now, if you happen to be new to my channel, let me especially welcome you. This is the podcast where we're going to be discussing all things constitutional law, as well as current events in other areas of law, politics, and culture. Now, let me just remind you guys real quick, if you want to find out more about the show, you can go check out our homepage over at legalesepodcast.com. And if you want to stay up to date whenever I put out new content, because I don't just do videos on YouTube, I post to alternative platforms. I also write articles over on Substack. And if you want to get notifications for either some or all of those things, all you have to do is head on over to legaleseshow.com, where you can subscribe to our newsletter. All right. Well, with that said, let's just jump right in. We have got a lot to cover here today. And we are talking, as I alluded to in the beginning, about the Supreme Court case of Garland v. Cargill. Now, just the other day on Friday, the Supreme Court handed down their decision in this exceptionally important gun rights case. Now, as we've been following here on the channel throughout this Supreme Court term, as part of my Supreme Court roundup, the Supreme Court has taken on several landmark gun rights cases this term. However, where Garland v. Cargill differs from all the others is that it does not turn on the Second Amendment. Rather, it asks whether a federal regulation that bans machine guns also applies to bump stocks. Now, the National Firearms Act of 1934 defines a machine gun as any weapon capable of firing automatically more than one shot by a single function of the trigger. And in his majority opinion, Justice Clarence Thomas notes, the definition also covers parts that are designed and intended for use in converting a weapon into a machine gun. And a bump stock is a device designed and intended to permit users to convert a semi-automatic rifle so that the rifle can be fired continuously with a single pull of the trigger. At least that's what they say, discharging potentially hundreds of bullets per minute. Now, this all came about in 2018 after a mass shooting in Las Vegas was carried out by someone who is believed to have been using a bump stock. And the Bureau of Alcohol, Tobacco, Firearms, and Explosives published an interpretive rule following that 2018 incident, concluding that bump stocks are machine guns as defined in Section 5845B. Now, in the decision in this case in the lower courts, such as the en banc Fifth Circuit, they would hold that the ATF rule was unlawful because the statutory definition of machine gun does not encompass bump stocks. And real quick, for a refresher, let's look at what the question presented in this case exactly was. So this QP asks whether a bump stock device is a machine gun as defined in 26 U.S.C. section 5845B because it was designed and intended for use in converting a rifle into a machine gun, i.e. into a weapon that fires automatically more than one shot by a single function of the trigger. Now, we have been covering this case extensively here on Legalese for the better part of 2 years, going all the way back to the Fifth Circuit opinion, which is the opinion upon which the government sought review in the case we're talking about today. Now, the reason this case has been receiving so much really extensive coverage here is because it really highlights the way that administrative law has come to play such an outsized role in defining and limiting the scope of constitutionally protected individual rights, such as the right to keep and bear arms.
Can I get armor-piercing cyanide-tipped bullets, too? It's in the Constitution, son.
Now, on the show notes page for this episode, I will include links to my articles and videos from the past that have been covering this case that go as far back as his first appearance before the Fifth Circuit Court back in May of 2022. Now, getting to today's decision, the Supreme Court struck down the rule banning bump stocks, which was issued by the Trump administration. Now, this is, and I just have to point this out whenever I have the chance, the most anti-gun administration in our country's history. However, in this case, by a vote of 6-3, the majority rejected the federal government's argument that rifles equipped with bump stocks are machine guns, which are generally prohibited under federal law. Now, in a majority opinion, which was penned by Justice Clarence Thomas, the court's conservative justices emphasized that Congress could have enacted a law that banned all weapons capable of high rates of fire, but it did not. And so the Bureau of Alcohol, Tobacco, Firearms, and Explosives was wrong to interpret the federal ban on machine guns to extend to bump stocks. And this case upholds the rule of law and the importance of separation of powers by striking a blow against bureaucratic attempts to impose new gun control without congressional approval. And of course, the bump stock ban is really only one of several such attempts. So for nearly a decade, the ATF took the position that semi-automatic rifles equipped with bump stocks were not machine guns under this exact statute. And Justice Thomas notes that on more than 10 separate occasions over several different administrations, the ATF consistently concluded that rifles equipped with bump stocks cannot automatically fire more than one shot by a single function of the trigger. Now, the dissenting opinion in this case was penned by Justice Sonia Sotomayor, and it was joined by Justices Elena Kagan and Ketanji Brown Jackson, and their dissenting opinion simply glides over the entire illuminating history of this case, which it only mentions in a single one-paragraph footnote. Now, the reason the ATF would abruptly reverse course on this happened when President Donald Trump maintained new legislation was unnecessary to ban bump stocks, and he simply instructed the ATF to impose a ban by administrative fiat. And in fact, back when Trump was still on Twitter, he made this unbelievable post that says the Obama administration legalized bump stocks, which is a lie. He says that was a bad idea. As I promised today, the Department of Justice will issue a rule banning bump stocks with a mandated comment period. We will ban all devices that turn legal weapons into illegal machine guns. Now, I just wanted to point this out because there are so many people who believe Donald Trump is going to protect the Second Amendment, and I always like to make it clear that this man is absolutely the most anti-gun fucking president in our nation's entire fucking history. And if this tweet doesn't prove it, I don't know what does. Now, because the approach that Trump wanted contradicted the statutory definition of a machine gun and the ATF's longstanding interpretation of that statute, supporters of a legislative ban warned that it would inspire court challenges that were apt to succeed. Now, the particulars of this case go back to an individual who would surrender 2 bump stocks he had to the ATF under protest. And this was Texas gun shop owner and U.S. Army veteran Michael Cargill, who would go on to file a lawsuit challenging the rule in the U.S. District Court for the Western District of Texas. Now, although a federal judge and a 3-judge panel on the U.S. Court of Appeals for the Fifth Circuit would uphold the rule, the appeals court would reverse the ruling in an en banc decision issued last year. And in that en banc decision, the court would say that a plain reading of the statutory language, paired with close consideration of the mechanics of a semi-automatic firearm, reveals that a bump stock is excluded from the technical definition of a machine gun set forth in the Gun Control Act and the National Firearms Act, and this was according to the Fifth Circuit Judge Jennifer Walker Elrod, who wrote the majority opinion for the en banc Fifth Circuit. And she would go on to say that even if that were not true, the rule of lenity, which requires construing an ambiguous criminal statute in a defendant's favor, would preclude the government from punishing people for owning bump stocks. Now, that decision clashed with a 2022 ruling in which the U.S. Court of Appeals for the D.C. Circuit would conclude that the ATF had followed the best interpretation of the statute. And by contrast, a plurality of 8 Fifth Circuit judges agreed that the ATF had violated the plain meaning of the statute. In resolving that circuit split, the Supreme Court would come in this case to endorse that latter view. Now, during the oral arguments before the Supreme Court that happened back in February, the principal Deputy Solicitor General Brian H. Fletcher conceded that an expert can bump fire a rifle without any assistive device at all. And also that you can also do it if you have a lot of expertise by simply hooking your finger into a belt loop or using a rubber band or something else like that to hold your finger in place. And dodging the logical implication that all semi-automatic rifles are machine guns, the ATF maintained that the additional assistance offered by bump stocks made some kind of crucial difference. And it was a highly technical 19-page ruling for this case in which Thomas would conclude that this law simply does not support the ATF's rule banning bump stocks. So first he explained, semi-automatic rifles that are equipped with a bump stock do not fire more than one shot by a single function of the trigger. Each time that a shooter fires the rifle, Thomas would emphasize, the shooter must release pressure from the trigger and allow it to reset before re-engaging the trigger for another shot. The bump stock, he wrote, merely reduces the amount of time that elapses between separate functions of the trigger by allowing the shooter to quickly press the trigger again. And so with or without a bump stock, the trigger has to be released and reactivated to fire additional rounds. And in trying to get around that basic fact, Thomas would note, the ATF relied on the mistaken premise that there is a difference between a shooter flexing his finger to pull the trigger and a shooter pushing the firearm forward to bump the trigger against a stationary finger. And furthermore, the ATF would call the shooter's initial trigger pull a function of the trigger, while ignoring that the subsequent bumps of the shooter's finger against the trigger happen before every additional shot and also would constitute a function of the trigger. But importantly, Thomas would go on to note that the statute, however, does not define machine gun based on what type of human input engages the trigger, whether it be a pull, a bump, or something else. Thomas would go on to write that it does not define a machine gun based on whether the shooter has assistance engaging the trigger. The statutory definition instead hinges on how many shots discharge when the shooter engages the trigger. Now, to help fully illustrate the problem with the ATF's workaround, the agency's reasoning contradicted itself. The rule defines function of the trigger to include not only a single pull of the trigger, but also any analogous motions. And the ATF indeed concedes that one such analogous motion that qualifies as a single function of the trigger is sliding the rifle forward to bump the trigger. And if so, every bump is a separate function of the trigger, and semi-automatic rifles equipped with a bump stock are therefore not machine guns. Now, the ATF claimed that a semi-automatic rifle equipped with a bump stock fires more than one shot by a single function of the trigger, because a shooter need only pull the trigger to maintain forward pressure and activate continuous fire. Now, Thomas notes that even if the ATF had been correct in declaring that bump firing constitutes more than one shot with each function of the trigger, then the same should be true for a semi-automatic rifle without a bump stock. After all, as the dissenting opinion and the ATF themselves acknowledge, a shooter manually bump firing a semi-automatic rifle can achieve continuous fire by holding his trigger finger stationary and maintaining forward pressure with his non-trigger hand. Yet they also agree that a semi-automatic rifle without a bump stock fires only one shot each time the shooter pulls the trigger. And it's so clear as Thomas goes out to point the obvious out that their argument is thus at odds with itself. And moreover, just as Thomas would continue, even if a semi-automatic rifle equipped with a bump stock does fire more than one shot by a single function of the trigger, it does not do so automatically. This is what the law also requires. And Thomas explained that if a shooter wants to fire multiple shots using a semi-automatic rifle with a bump stock, he must also actively maintain just the right amount of forward pressure on the rifle's front grip with his trigger hand. And this additional input from the shooter, Thomas would reason, means that these shots are not automatic. Now, while this really arcane analysis might seem to you like just me nitpicking, it is exactly what a court must do in seeking to apply a statute such as this as written. As the Assistant Solicitor General Brian Fletcher conceded in oral arguments, Congress did not define a machine gun by rate of fire. He said, quote, "This is not a rate of fire statute, it's a function statute," end quote. Now, although it may seem logical that any weapon that can approximate a machine gun's rate of fire should be placed in the same category, that is not the law that Congress wrote. And Justice Samuel Alito penned a short concurring opinion in which he emphasized that the majority's ruling reflected the only way to interpret the ban on machine guns. So Alito would say there is a simple remedy for the disparate treatment of bump stocks and machine guns. Congress can amend the law, and perhaps would have done so already if ATF had stuck with its earlier interpretation. And he says now that the situation is clear, Congress can act. Now, Justice Sonia Sotomayor would dissent in an opinion that was joined by the other liberal justices, Elena Kagan and Ketanji Brown Jackson, and she warned that the majority's decision will have deadly consequences.
Steiner konnte nicht genügend Kräfte für einen Angriff massieren. Der Angriff Steiner ist nicht erfolgt.
Das war ein Befehl! Der Angriff Steiners war ein Befehl! Wer schickt mich belogen? Jeder hat mich belogen, sogar die SS! Die gesamte Generalität ist nichts weiter als ein Haufen niederträchtiger, treuloser Feiglinge!
Mein Führer, ich kann nicht zulassen, dass die Soldaten, die für Sie
Nicht
verbringen...
als Feiglinge! Verreiter, Versager!
Mein Führer, was Sie da sagen, ist ungeheuerlich.
Die Generalität ist das Geschmeiß des deutschen Volkes!
And in her dissent, Sotomayor would read the text of the federal ban on machine guns differently. Now, she would emphasize that, according to her, this is not a hard case. She argued that all of the textual evidence points to the same interpretation, that semi-automatic rifles equipped with bump stocks are machine guns. And she does this by focusing on the fact that a shooter using rifles equipped with a bump stock can fire multiple shots with one pull of the trigger, as long as he maintains the forward pressure on the barrel or front grip of the rifle. And so Sotomayor would fault Thomas for focusing instead on the internal mechanisms that initiate fire within the rifle. And more broadly, Sotomayor would contend, Congress wanted to restrict the availability of machine guns because they eliminated the need for a person rapidly to pull the trigger himself to fire continuously. And she suggests that a bump stock serves that function, allowing a shooter to fire at a rate as high as 400, 800 rounds per minute. And by casting aside the statute's ordinary meaning, both at the time of its enactment and today, the majority eviscerates Congress's regulation of machine guns and enables gun users and manufacturers to circumvent federal law. Now, on the other hand, Justice Thomas would push back against Sotomayor's suggestion that the majority's decision makes it too easy to evade the ban on machine guns. He would write that a law is not useless merely because it draws a line more narrowly than one of its conceivable statutory purposes might suggest. And particularly when, in 2018, the ATF did not interpret the law as banning bump stocks. And so, whatever the merits of a bump stock ban, the simple fact is that regulators cannot rewrite the law to impose one, especially when that decision transforms gun owners who abided by the law, as the ATF had repeatedly explained, into felons overnight. And similar bureaucratic reversals concerning pistol braces, homemade guns, and the definition of a firearms dealer all raise the same basic problem. And this includes a recent case in which a federal judge in Texas would vacate an ATF rule that redefined pistols with braces as short-barreled rifles under the National Firearms Act. And U.S. District Judge Reed O'Connor would describe that rule as both unlawful and illegitimate. And in another Texas case, just this last week, a federal judge temporarily blocked an ATF rule that sought to expand background checks for gun buyers by requiring that anyone who sells guns to, quote, predominantly earn a profit, end quote, obtain a dealer license. Now, all of these cases raise an issue that goes far beyond the particulars of gun regulation. And that is because due process, the rule of law, and separation of powers all preclude the executive branch from inventing new crimes by twisting the meaning of statutes in response to political pressures, which is exactly what the Trump administration did, and did proudly. On the bright side here, the Supreme Court does appear to be remaining vigilant and proactive when it comes to curbing the ATF's constant attempts to rewrite the meaning of laws in any way that will allow them to exercise powers that they were never actually lawfully delegated. To wit, the justices agreed to take up the case of Garland v. Vanderstock in their next term. And this case challenges the Biden administration's efforts to regulate so-called ghost guns.
This is a ghost gun. This right here has ability with a .30 caliber clip to disperse with 30 bullets within half a second. 30 magazine clip in half a second. This is a ghost gun. This right here has ability with a .30 caliber clip to disperse with 30 bullets within half a second. 30 magazine clip in half a second.
And that case will likely be argued in their next term sometime in October, with a decision to follow sometime in 2025, and you can be sure that that is the case I will be covering in my next term as part of my Supreme Court roundup. Well, anyways, that's really all I have for you guys here today. Thank you so much for tuning in to Legalese. If you like the show, if you could please take a moment and do all of those things for me that help to trigger Al Gore's rhythm. So if you like the video, go ahead and hit that like button. If you didn't like the video, you can go ahead and hit the dislike button if you want to be a dick about it. Definitely ring that bell and subscribe to the channel so you always know when I put out new content. There's going to be a bunch of important Supreme Court cases coming out over the next couple weeks. You're not going to want to miss my videos on that. And also, take a moment and leave me a comment and let me know what you thought about this video or what you thought about this topic in general, or just whatever. I always really enjoy getting a chance to read your guys' comments and interacting with you down in the comment section as much as I can. So if you guys would do all that for me, I would be truly grateful. And until next time, this has been Bob for Legalese, talking about Garland v. Cargill, and of course, as always, Carthago delenda est.